On today's these topics, legal and political stories ripped from the headlines, but analyzed and explained. What is happening with the Manhattan DA's criminal case and grand jury against Donald Trump for the crimes arising out of the Stormy Daniels hush money payment and cover up? Is the grand jury meeting this week again to finish? Are there more rebuttal witnesses? And if so, why? And if they indict, when can we expect surrender, arrest, and arraignment? Then we're going to turn to, speaking of Trump's latest crimes, what does the D.C. Circuit Court today upholding the chief judge's Friday ruling that Trump likely committed a crime related to the Mar-a-Lago secret documents that he withheld, destroying attorney-client privilege around his conversations with Evan Corcoran, and compelling Evan Corcoran to turn over his notes and maybe recorded phone conversations he had with Donald Trump. He had recorded phone conversations with Donald Trump. What's that about? And what will Trump do next? Then we're going to talk about Fani Willis down in Fulton County, Georgia, facing some headwinds, seeking to recall or remove her, and a new motion to dismiss filed by Trump's latest attorney team of Little and Findling, or Findling and Little, against the special purpose grand jury and all their work. But she's going full steam ahead with calling Christina Bobb, late of Mar-a-Lago, who needs another criminal defense lawyer because she's a witness regarding Trump's infamous "let's find 11,780 votes" phone call and other events around that. And we thought her lying to the Department of Justice about how many classified documents were hiding in Mar-a-Lago was bad enough. And then finally, we're going to talk about, well, criminal cases may put Donald Trump into jeopardy of losing his liberty. What Trump fears the most is how about financial ruin? And we're going to talk about two cases that are going on now that have major updates. One of them being the New York Attorney General's $250 million corporate death penalty case that is going to trial in October. And a judge just this past week denying efforts to buy another 6 months of time by Donald Trump's team to help to find witnesses and documents that they couldn't find during the last 7 months. And then finally, Judge Kaplan of the federal court in New York threw the lawyers for a loop, but not just this, by telling the lawyers for E. Jean Carroll's civil rape case that they're picking a jury on April the 25th, period. And that's going to be the case of the civil rape that she claims happened to her in the department store dressing room, and the defamation case related to that. All that and so much more on the midweek edition of Legal AF. I'm Michael Popok. I'm joined by my regular co-anchor, Karen Friedman Agnifilo, who's sitting either in CNN, MSNBC, or somewhere else, but she's exclusive to us at Legal AF tonight. And because we can't go man to man to cover all these breaking stories, we can only go zone. So I asked the co-founder of Legal AF and my weekend anchor buddy, Ben Meiselas, to join us for today's ride. Karen and Ben, thanks for being here.
Good to be here.
Good to be here. Great hanging out with you. I think I like, Popok, your intros better than mine because my intros take about 10 minutes and then I actually say everything that happens. I just get so excited talking about and geeking out about the law that I just basically say everything that's going to happen. You kind of give it a tease, though. You say, stay in there. We are going to explain to you.
You know where I learned teasing? From Ben Meiselas over the last 2.5 years. No better teaser related to.
You have to give context. You can't just say that. In terms of you have to
Legal AF.
In terms of the headlines that we post on YouTube. So just be very clear.
Agreed. Now, while we have Karen, and literally she's about to step into her 5th or 6th major network show tonight as a legal commentator, because who better to commentate about all things Donald Trump in the Manhattan DA's office than the former number 2 in the office, Karen. So let me kick it off, and I'm going to turn it right over to Karen. Here's what we know from the last show and from all the hot takes that the three of us have been doing almost hourly about everything that relates to Trump. That's how fast the wheels of justice, the velocity at which they are moving. So in the Manhattan DA's case, we all predicted that there was going to be an indictment this week. And I'm not saying there's not going to be. We also said that a grand jury meets on certain days and certain times. It doesn't meet at other days and other times. But I think we just threw that out the window. So we have an update that the grand jury is meeting Thursday, which is, they're not a Thursday grand jury, but they're meeting on Thursday, that there may be other witnesses. I want to talk about Cohen versus Costello and maybe bring Ben in for that as well. And then if there is an indictment this week, which again, all signs are pointing to it, but Karen's going to tell us what she thinks, then how do you sequence indictment, surrender, and arraignment to, not have mass chaos in Manhattan? And of course, Karen's going to give us a sequence on that. So Karen, let's kick it off. What is going on with the announcement that there's going to be a tomorrow, Thursday session of this grand jury? What do you think it means in terms of the indictment? And then we'll backfill with Costello versus Cohen as witnesses, maybe another witness, and then that sequence of indictment, surrender, and arraignment. Go ahead, Karen.
So if you remember, this is a special grand jury that was called because this is a long-term investigation. And that's a common thing when you have a long-term investigation, to create a special grand jury. And the only difference is they sit for a longer period of time, because grand juries, regular grand juries, are normally 2 weeks or 4 weeks. And so this, they apply to a judge, they get an order that they can sit for whatever it is, 6 months, 8 months, a year, depending how long they think that it will take to present evidence. So this is a special grand jury. Unlike the Fani Willis Fulton County special grand jury, this grand jury can indict, so they can bring charges. So what happens is with special grand juries is they usually meet mornings or afternoons. This is an afternoon grand jury. We know that because we know when Michael Cohen testified, and they usually meet 3 days a week. And we've always known they met Monday and Wednesday based on witnesses. What we didn't know until recently was the third day is a Thursday afternoon. So that's sort of how the grand jury is set up. So we also knew that they were nearing the end of the grand jury when they, at the grand jury presentation, I should say, when they gave notice to Donald Trump and gave him an opportunity to testify, because that's about the last thing you would do once you've already started presenting evidence. And so they gave him notice, and he decided not to testify. And instead, what he did was he asked to have Robert Costello, Michael Cohen's attorney, come in and testify. And a defendant has a right to ask that a particular witness or particular evidence be presented to a grand jury. And the way it works, a prosecutor goes in, they ask the grand jurors, they say, look, Donald Trump has requested that you hear from Robert Costello. Are you interested? Would you like to hear from him? And then you step out and you let them, they actually vote on that question. And if they vote yes, that they want to hear from him, then the prosecutor goes back in and says, okay, we'll have him come testify. So he came and he testified on Monday of this week. And from his own account, we've learned that he testified for about 2+ hours. I think it was 2 hours and 50 minutes roughly. Now, grand jury presentations, it's a lower burden of proof. It's not like a trial where you have to prove your case beyond a reasonable doubt. There's also no opening statements. There's no summations. There's no cross-examination. And it's a lower standard, which is a reasonable cause to believe that a crime occurred, or a probable cause, which is like, it's more likely than not. And so it's a lower standard of proof. And so as a result, prosecutors, when they put evidence in a grand jury, they normally do what's called a bare bones presentation. They don't do a full-blown evidentiary presentation like they would at trial, where they put all the evidence in, all the details in. But in this particular case, it looks like this was a much deeper grand jury where they put lots of facts in. And here, I think they had to, because there were some positive facts and there were some negative facts about this case. Michael Cohen comes with some baggage. And so as a result, they had an obligation to bring that out in the grand jury. And they also had an obligation to corroborate him. So this was a very thorough grand jury presentation. But Costello testified for about 2 hours and 50 minutes, almost 3 hours. And that's a very long period of time for a witness to testify in the grand jury. So he had an opportunity to say whatever he wanted. I can't imagine that there was anything else he wanted to say that he didn't get to say. And so that happened on Monday. And then there was a lot of speculation, knowing that the grand jury doesn't meet Tuesdays. There was nothing going to happen on Tuesday. And so today was the day everybody was waiting for, to see what's going to happen. And we heard that the grand jury was asked not to come in today. and they're not meeting, but they were asked to be on standby and potentially come back tomorrow. And that just tells us that they weren't ready to do anything today. And the question is why? Why didn't they do anything today? And I think if I were to surmise what's going on, I think it's two things. I think number one, they wanted to at least consider putting in a rebuttal witness, someone to rebut what Costello said. And my best guess would be Michael Cohen. They may put him in, they may not put him in, but I'm sure they're considering it. And so that makes sense that that's what they're doing. What they're doing right now, they're considering whether to put him back in to rebut certain information. And so I can imagine seeing him testify tomorrow. Now, the question is, will they vote tomorrow? Now, you don't just then walk out and vote. What happens is you then charge them on the law, and then you ask them to vote, and deliberations can take time. Sometimes they vote right away, but they actually deliberate. It could take minutes, it can take hours, it could take days for them to deliberate. They need a majority. There's 23 grand jurors, and they need a majority. And so we'll see. Now, there's been lots of questions about, could Alvin Bragg be changing his mind and not seek a vote? I find that highly dubious. I think he will ask them to vote. And frankly, if the grand jury does not vote and the evidence is such that the prosecutor couldn't get an indictment here, it's better to know that now. It's better to know now that the case has problems. And it's better to know now that you can't, because if you can't prove the case, with this lower standard, you certainly can't prove the case beyond a reasonable doubt. So the third reason, though, that I think we might not have a vote tomorrow is because if I were the prosecutor, what I would be thinking of, I'd be talking to law enforcement about security, because there's a lot of security concerns here, keeping both Donald Trump safe when he surrenders, but also keeping New Yorkers safe. Unfortunately, Donald Trump has been calling for protests, and we saw what happened when he called for protests on January 6th. And there's a lot of that kind of language here. And so, we have to be careful about about how this goes down, right? So if law enforcement is making arrangements right now with the Secret Service, both because of Donald Trump's schedule, but also for security, what would be a good day and time to have him surrender? Also with the court, right? When can the court hear the case? And whenever that date is, I think you work backwards from there and you ask them to vote the last possible time before that date. At least that's what I would do, because I wouldn't want a lot of sunshine between the vote and him coming in, because there's a lot of stuff that he can make happen. He's a troublemaker, and he will drum up a lot of potential violence. And so if I were law enforcement, that's what I'd be thinking about. And so I would consider holding off voting for a period of time. That certainly wouldn't be an unreasonable position to be in if that's what happens.
So let me unpack some of that. Then I want to bring Ben in about Michael Cohen versus Costello and his thoughts on that. So I agree with you completely. There's no way Alvin Bragg has gone this far, and he's not going to try to count to 12, which is the majority of the people that make up the grand jury, to try to get an indictment. If they've run into a little bit of headwinds on one witness, and they always knew, look, they're no fools. Alvin Bragg was built for this job based on his past and having gone after Donald Trump when he was at the New York AG's office, which is part of his career, his body of work. He knew Michael Cohen there were going to be some issues with Michael Cohen's credibility, and they were ready. Robert Costello was not a surprise to them that the grand jury may have asked for that. To clear it up, some people suggested, and Trump tried to jump on this bandwagon, that they demanded that Alvin Bragg bring Robert Costello in as a witness, and that's why Robert Costello came in. That's not why Robert Costello came in. Robert Costello came in because it came up there, as Karen explained, during the grand jury process, that this was something to counterbalance it. What did you think about Costello taking the podium and giving a press conference about what he had testified to immediately upon concluding his testimony? What'd you think about that?
Are you asking me or are you asking Ben?
Yes. No, I'm asking you. Then I want to get to Ben about Michael.
I mean, look, all the rules are out the door here. You know, if I were the prosecutor in this case, I wouldn't be happy that Michael Cohen is talking in the press and creating statements. But, you know, that's what everyone's doing here. Everybody's is trying to they're trying their case both in the court of public opinion as well as in the actual court. So
I also love your sequencing, because I don't think you're seeing this at any other program, at least exclusively to Meidas Touch, is the no daylight between indictment, surrender, and arraignment. Let's put aside extradition for a minute. I don't think anybody believes now that Donald Trump, who looks like, based on reporting, he's looking to have handcuffs and do a perp walk in his bizarre, adult way, narcissistic way. He wants the perp walk. Putting that, so let's say that also means he's going to self-surrender and they're going to arrange it as Karen laid out. I love that analysis that Karen gave, which is no daylight, quick indictment, right to surrender, right to arraignment, and let's try to manage this outcome, shape this outcome that will inevitably happen with Trumpers and protesters and whoever and bomb scare people and all of that. Ben, let me bring you in because you've got a daily relationship with Michael Cohen. I don't know what his opinion is about Costello. I've heard it in the press here and there. What do you think about what's going on about tomorrow, indictment, Michael Cohen versus Costello, and anything else that you can think of?
Well, look, I have no inside information regarding one way or another the answer to what I'm about to say. But look, Cohen was there on Monday after Costello finished his testimony to serve as a rebuttal witness. What we know publicly is that he was at least told on Monday afternoon his testimony wasn't needed. I don't know if Cohen's subsequently been told something different, that he's going to need to go back there on Thursday. But let's rewind for a little bit and just remember who Costello is in relation to Cohen. So Costello was a legal advisor to Cohen in the 2018 period. And during the Mueller investigation, when ultimately the FBI raided Michael Cohen's office, you had Costello send this infamous email to Cohen, which is talked about in the Mueller report in volume 2. And Costello said, quote, "Sleep well tonight. You have friends in high places." And then he later told, I think it was the Daily Beast sometime in March of 2018, that he wasn't talking about Donald Trump, but he was referring to a Garth Brooks 1990s song, Friends in Low Places. He later changed that and said, yes, I was referring to Donald Trump. And let's not forget that in volume 2 of the Mueller report, it says the following about that interaction. In analyzing the president's intent in his action towards Cohen as a potential witness, there is evidence that could support the inference that the president intended to discourage Cohen from cooperating with the government because Cohen's information would shed adverse light on the president's campaign period conduct and statements. So this is who Costello is. Costello is also somebody who's represented Steve Bannon. Costello is inextricably intertwined in Trump world as one of these kind of shady Trump lawyers who are engaged in bad acts. When Cohen had his mea culpa and said, I don't want to deal with this world anymore, it was a rejection of the Costellos of the world. So Cohen definitely does not have anything resembling a positive view about Costello. And I think Costello's credibility, just based on his statement about the Garth Brooks lyrics, tells you all you need to know about who Costello is. That said, when Costello goes in there on Monday and has kind of free reign to say whatever, do you want to clean that up? Whether it's with Cohen or someone else, do you want the last witness, if you will, up there to be a Trump person saying all of those things? I think that's ultimately one of the considerations. And look, we thought the fact that they didn't call Cohen on Monday was a sign that Costello's testimony was not impactful. That still may be the case. We don't know what's going to be happening on Thursday. But I think ultimately when we find out, and again, I don't know at this moment if Cohen's going back. Cohen's been very careful, though, in terms of his public statements, what he said and what he hasn't said. He's only talked about things that were already publicly available, and he's been very, very, very careful to that extent. So ultimately, we'll see, but I want to give you that color in terms of the dynamic to who Costello is and who Cohen is.
Why I like that, and I want to get Karen's opinion, is it reinforces what Karen said earlier, which is there's no cross-examination. He just goes in and gives his narrative. And do you want to end on a low note if you're the prosecutor? Okay, prosecutor Karen, do you want to end on a low note? What do you think about Ben's theory that one of the reasons they want to bring in a new capstone person to end the process is because they don't want to end on a Costello note?
Yeah, I'm sure that's it. And I'm sure he raised some points that if it turns out they weren't true or they were, you can prove that factually, you're going to want to rebut that for sure.
Yeah, so this is what we're following. And I see a lot of things, we're watching the chat tonight. We're live. And so a lot of people are like, well, Ari Melber said this, and maybe they're not going to indict. I think it's exactly the way that Karen laid it out for us. It could happen tomorrow at the conclusion of whatever witnesses they may or may not take in. It may take them longer because they really do deliberate. It may take them longer to deliberate. There's still that prosecutorial discretion that has to be exercised by Alvin Bragg about whether he's going to go for the indictment. I think that's sort of a fait accompli. He's gone this far. We think it's a felony, of course, not a misdemeanor. And then if it comes out, and you and I, the three of us, are all scrambling to get back to our laptops and microphones to give a hot take or a collective new show about the indictment and what happens next, the timing is important. Thursday, Friday, Saturday. If I were the prosecutor, knowing Manhattan right now on a Friday, which is sort of empty or emptier, I would try to time it so that all these things sort of happen on Friday, and then we're maybe using a little bit of the weekend for the surrender and the arraignments on Monday, Tuesday, perfectly sequenced the way Karen laid out. Are these?
Can I say this one thing, Popok?
Of course.
The media narrative, though, let's recall before, was that the Manhattan District Attorney was never going to indict, right? I mean, we would always look in the chat and Ari Melber said this, or this person on MSNBC said there's absolutely no way Alvin Bragg is going to indict. Look, we've always here on Legal AF, on the Meidas Touch network, have had a very steady hand. We followed the data. We're not just going where, hey, there's a advantageous leak from one side. We're following where the data is. We remain kind of calm and confident in what we are predicting. And let's not forget that these media narratives, whether it's the red wave or whether it's Alvin Bragg's never going to do this or this person, let's also reflect for a moment that the very reason why we have the Meidas Touch network, why we have Legal AF, is because these media narratives have this kind of ping pong back and forth of kind of outrage and salaciousness.
You know what I love about the show, and the reason I joined it early on and you and I got together for Legal AF to found it? We don't have a narrative. There is no narrative. The narrative is what are the facts today that need to be unpacked and analyzed and presented and curated by the Legal AF team and by the Meidas Touch team. That's the narrative. Yes, we come from a progressive standpoint, but it's exactly the way that Ben just laid out. Karen, can you stay with us for a little bit? Literally, you're in a green room waiting to go on another network.
I know. Look at this hair and makeup. I don't normally look like this,
The fans on chat are very, very happy that with whatever's happened today with you.
It's all fake. It's all fake.
I think you always look great. And do you want to do a shout out to some children who are having a birthday today?
Yes, today is my twins' 26th birthday. So Sophia and Alexandra are 26 today.
What kind of number is that you're throwing around? Be careful with it. 20s. How's that even possible?
Yeah.
But we're glad. But seriously, look at the dedication and devotion of the people like Karen to the show and to justice and what she's doing with us today. So let's spend another couple of minutes talking about something else while we still have the benefit of our former prosecutor colleague in Karen. And let's talk about Lago and a recent development. Talk about a high velocity locomotive of an appeal. It literally went from a ruling related to whether Evan Corcoran was going to testify against Donald Trump effectively, being stripped of his attorney-client privilege for all things Mar-a-Lago and the documents, be stripped naked by the Department of Justice, including having his pockets picked of all of his attorney notes, of all of his apparently, this is the way I read it. I want to hear Ben and Karen's perception, whether he was recording phone conversations with his client, and there's transcripts of those. That's what I've read. And that needs to get immediately turned over. Per Beryl Howell, who was on her last day of being a chief judge for the D.C. Circuit Court. Don't worry, people, she's not going anywhere. She's just going back to being an everyday trial judge, handling cases like Rudy Giuliani's defamation case. So she's still very much in the thick of things. But she, it's a term of 7 years. Her 7-year term is over. And Jeb Boasberg is coming in. We shouldn't worry about him either. She makes the ruling on Friday. There's an immediate attempt at an appeal by Donald Trump's team over the weekend. And the 3-judge panel, all democratically appointed, 2 Biden appointed, no less, they decide, yeah, you want to have an appeal? Let's put an appeal on, but let's do it in hours, not months. So we'll give the Department of Justice 9 hours to file Trump 9 hours to file his papers, and we'll give the Department of Justice 7 hours to file their papers, and we'll have everything fully briefed literally by 6 a.m. today, this morning, with some briefs that were due at midnight the day before, and then 8 hours later, the appellate court ruled against Donald Trump in favor of the Department of Justice, finding that the finding by Chief Judge Howell that there was a likely crime committed by Donald Trump on a prima facie standard, it related to the Mar-a-Lago documents, and one step further, that he created a criminal scheme dating all the way back to the initial interactions with the National Archives. And he was at the heart of that scheme, destroying all attorney-client privilege between him and people like Evan Corcoran, who was his ringleader about Mar-a-Lago and the documents from the National Archives through the subpoena process, through the search warrant execution in August, and Christina Bobb being brought along as a sidecar along for the ride, and also signing declarations and sworn statements to the Department of Justice that were incorrect. The trial judge said, I don't know if there was a conspiracy with the lawyers, but at the very least, they were unwittingly a part of the crime committed likely by Trump. No attorney-client privilege. Go into court tomorrow and testify to the grand jury, Mr. Corcoran, and take your documents with you and give them to the Department of Justice. So the 3-judge panel comes in, and Ben, why don't you jump in with the result of the 3-judge panel, and then we can get Karen's perspective of why are we going so fast? Is this a sign that we're on the 5-yard line with Mar-a-Lago prosecution with Jack Smith? And I want to hear from the prosecutor. But Ben, why don't you tell everybody what happened?
3-judge panel immediately affirmed Judge Beryl Howell. And just to go over what Popok said, Judge Beryl Howell made the ruling that Donald Trump had committed criminal violations based on the evidence that's presented. Again, it's a lower standard at that point. It's not actually having to prove the case in front of a jury, but Judge Beryl Howell made the finding that a criminal scheme took place. Donald Trump appeals that. It's a rocket docket like I've never seen before, which raises other questions that I wonder from Karen what she suspects is going on here. I mean, I've seen briefing schedules get back to us in 48 hours, even 24 hours. They wanted full briefing by the DOJ and Donald Trump's lawyers basically totally within a span of essentially 12 hours, and then immediately rejected Donald Trump's arguments, affirmed Judge Beryl Howell. And we're talking about documents that could not just be the smoking gun, but like the smoking gun. We're talking about potential audio recordings between Evan Corcoran, Trump's lawyer, and Donald Trump, about Donald Trump's statements about what he was doing or what he knew about these classified records that were being concealed at Mar-a-Lago. I mean, this is big, folks, and the timing and the quickness within which this is moving is big. Karen?
The only other place I've ever seen this kind of timing is on my other job, where I'm the legal advisor for Law and Order. This is like TV time, right? Where you do things so quickly.
One episode.
It's crazy, right? I've never, ever seen timing like this before. And what that tells me is one of two things is going on. Either there's some kind of national security issue, right, in happening, but that doesn't seem likely, but that's possible. Those are the types of things that make things like this happen. Or the other possibility, actually there's two other possibilities. The second possibility is I think judges are getting fed up with Trump's delay, appeal. I mean, it's ridiculous at this point. All of these things have taken so long because of his MO of delaying everything. And I do think judges are losing patience with that and getting a little bit frustrated. But finally, yes, I think it really means that Jack Smith is nearing the end of his case. And he's basically pressuring the court saying, our grand jury's here. And, look, grand jurors don't sit forever, right? They are called for a period of time and you can always extend it, but, you need to kind of wrap things up. And Mar-a-Lago documents, that's, in the obstruction of justice and that whole case, that's a fairly straightforward case. That's not as sweeping and vast as the Jan 6 election interference case, which is much bigger and will have many, many, many more witnesses and more facets and will take a very long time to present. This is a pretty straightforward case. It's not that complicated. And this, I think, shows us that we are very close to hopefully seeing a grand jury vote in that case as well.
That's what I think. I think it is, we're on the 1 yard line with Jack. He's given the signal to the judges involved that they want to wrap this up. It's not like New York where you have to, or, traditionally give the target the opportunity to come in and drop immunity. They're not going to offer Donald Trump the opportunity to come in and talk to the grand jury. They don't need him. They're not going to use him. And they've exhausted all their other witnesses. I mean, how many lawyers are going to be stripped bare without their privilege in front of a jury to testify? How much immunity are they going to give people to come in and testify? We've always said, and Ben and I originally said, that the Mar-a-Lago case, before there was a January impaneling of the New York case, which took on a whole nother velocity that I've never seen you have, Karen, from January to March, maybe we'll push to April, but March for an indictment. That is Law and Order episode style stuff. But for Mar-a-Lago in a federal style, we said there's like 30 facts that need to be proven by like 10 witnesses. And it's not that complicated. And so that we thought of all the various grand juries that Jack Smith was handling and inherited from Merrick Garland, that would be the quickest one to go. And then we talked about Fani Willis at one point because she kept saying imminent, and that threw us for a loop. We thought imminent meant like imminent. And so we were left with everybody kind of catching up to Alvin. Who would have thought? Who would have thunk we would have said this? Everybody's catching up behind the slipstream of Alvin Bragg to see who's going to be number 2 in terms of the prosecutors that are prosecuting. But I think you're right.
And can I say this, Popok?
Sure.
And everyone's catching up, and we knew this all along, what a superstar Karen Friedman Agnifilo is. And it's so incredible. We're so fortunate to have her as a co-host of Legal AF because, we've been doing this together for a very, very long time now.
2 years.
And to see Karen Friedman Agnifilo on all of the media networks sharing her expertise. I mean, she led the Manhattan District Attorney's Office. She's the number 2 deputy there. So there really is no bigger expert ever than Karen Friedman. And in addition to that, being a great person and a great person.
I'm going to tell a great person story for Karen before she has to leave, because I never told this origin story. So Ben and I wanted to do another episode of Legal AF. And we talked about having a different voice than he and I are in private practice more, and we were looking for a different voice. And so I had a friend of Karen's in mind who ended up getting a big job with the governor. And so I was kicking it around with Karen. And Karen said to me, because that person became quickly unavailable, she's now got a big job with New York State. And Karen said, "What about me?" And I had just met Karen. I had just met Karen, but I liked her immediately. I don't know if you remember the event we met at.
I do. We were standing on the street. We were at the corner, standing on the street, and you're like,
in front of your office building.
Yeah,
and you jumped in. And you jumped in and said, "What about me?" And I instantly said, "What about you? That sounds like a great idea." And I think the next week we launched Legal AF midweek, and that's how it happened.
I will say, I remember that exactly. And I will say for all the women, the young women and women out there, it's all about speaking up for yourself and leaning in, as they say, right?
That's
and
right.
That book. And so that was I had just left my job of 30 years. I wasn't sure what I was doing with myself, but I did say, "What about me?" And Popok, The rest is history. Here we all are together.
That's
So
it. And,
thank you.
Look at you. All right, Karen. We don't want to. You're literally going on multiple networks tonight, so I
Yeah,
think
I'm going on MSNBC with Alex Wagner
all
next.
right, everybody, stay with us.
Yeah, stay with us.
Ben is stay. You can watch her on tape repeat, but Karen, thanks for joining us in the middle of everything. We really appreciate you.
Bye.
We'll see you
Bye.
probably in the next few hours. All right. All right. Thank you. And now's a perfect time while we're kind of switching gears here with Karen leaving to go to her other night job to talk about one of our sponsors, ZBiotics.
And now let's take a quick break to talk about our next partner, ZBiotics. You ever skip a workout because of drinks the night before? Well, me too. If you're committed to your healthy routine this year, you need ZBiotics. ZBiotics Pre-Alcohol Probiotic is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. So here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics, it produces an enzyme to break this byproduct down. It's designed to work like your liver, but in your gut where you need it the most. Just remember to drink ZBiotics before drinking alcohol. Drink responsibly and get a good night's sleep to feel your best tomorrow. The first time I tried ZBiotics was on vacation with my wife. As instructed, I drank a bottle of ZBiotics before any alcohol, and I was amazed at how good I felt the next day. Give ZBiotics a try for yourself. Go to zbiotics.com/legalaf to get 15% off your first order when you use legalaf at checkout. ZBiotics is backed with a 100% money-back guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember, head to zbiotics.com/legalaf and use code legalaf at checkout for 15% off. Thank you, ZBiotics, for sponsoring this. And now, back to the video. Lock him up! Indictment season is upon us. Celebrate with the new Indictment season t-shirt and v-neck exclusively at store.MeidasTouch.com.
Salty, our producer, threw me for a loop on that one. I wasn't ready for that last lock him up. I wasn't sure.
Same thing on the podcast I do with the brothers. The first time I saw that,
Right? I almost fell out of my chair. All right, Salty, keep us on our... Well, let's keep Ben on his toes. We got 2 left, and I'll let you pick them. You want to do what's going on with Fani Willis and Georgia first?
Let's start off with Fani Willis.
All
Donald Trump and his team, they filed a motion to quash the report by the special grand jury and to disqualify Fani Willis and also to essentially disqualify the judge. It's kind of right out of Trump's playbook, right? The judge engaged in improper conduct, the district attorney engaged in improper conduct, the special grand jurors engaged in improper conduct. Look, here's the thing. In terms of what the report is or what the content of it is that's prepared by the special grand jury, guess what? Oh, it's still sealed. We don't know what's being recommended in there. And so remember, the process in Fulton County, Georgia, that Fani Willis, the district attorney, availed herself to, was a 2-step process. First, it went before a special grand jury. Unlike the grand jury in Manhattan, the special grand jury does not have the power to indict. The special grand jury in Fulton County does not have that power. It just has the power to prepare a report making recommendations. Now, that report can be taken to another grand jury. The time frame for one grand jury's meet in Fulton County, it meets in early March. There's another one that meets in May. You can take that report and present it to the Fulton County actual grand jury that has the power to criminally indict. But without even knowing what's in the report, Donald Trump is saying, my rights have been prejudiced. He cites, for example, one of the special grand jurors who spoke to the media, Emily Kors. He cites how Judge Robert McBurney spoke to the media. He's attacking the judge. That's one of the kind of common themes we see with Donald Trump, just attacking the judges, attacking the district attorneys. He also attacks Fani Willis, says that she engaged in improper conduct, and then also said that the very essence of the special grand jury procedure in general is unconstitutional. And so for all of those reasons, he's saying before an indictment even takes place, we got to quash the report, just destroy it, basically. And there's, there's really no.
And beyond that, one other thing, because I saw Finling on Ari Melber. I have a new test. If you can't get over being cross-examined by the talk show host like George Stephanopoulos or Ari Melber, you have no place in a courtroom. It's not just
They're both very
just,
good, though.
they are very good.
Really
I agree, but they're like eviscerating these people. But one thing I wanted before I let you go right back to your rhythm is it's not just the report. They are challenging the whole process, all of the witnesses that came. They don't want her to be able to use the witness testimony. All the people they brought in. Just she have to do it all over again. But of course, it doesn't even reflect. She never needed to use a special purpose grand jury. She could have gone directly to a regular grand jury. But now, of course, they want to set her back and make her do it all over again while attacking McBurney, the judge that was presiding over the whole thing. Sorry, Ben, keep going.
No, one of the things we know about Fani Willis as well is that she's had success before using RICO or racketeering charges, basically in gang cases where the head of the gang often kind of speaks in code and doesn't really directly issue the order, but can do it just based on kind of a pattern and practice. And everybody kind of knows where they fit in the kind of gang structure, but you're able to basically charge all the way up to the top of the gang through a common pattern, course of conduct, and conspiracy. One of the things that we're learning as well from various sources and reporting is that she's considering doing a RICO racketeering case here with Donald Trump. And so Trump is absolutely terrified by this case as well for his conduct relating to election interference. We're also learning that there was more than just the one phone call to Brad Raffensperger where he threatened Raffensperger to find him the 11,780 votes. There was also a phone call threatening the late Speaker of the House, a Republican Speaker of the House, Ralston, and then even one other phone call to local election officials. So there's actually
to an investigator to try to get her off the trail.
So there's actually 3 recorded phone calls taking, that have been presented.
Which is where Christina Bobb comes in, because now faced with all these headwinds and by the way, you don't think she's going to get recalled or removed because of these laws that are trying to be passed.
And here's the thing. Right? Look, I don't. Right. This is a frivolous motion. And here's the thing. Donald Trump, if he wants to bring that type of motion, if he believes there was prejudice or prosecutorial misconduct, which I absolutely don't think took place, here's what you do. You bring it post-indictment. You get indicted, you file a motion with the judge based on prosecutorial misconduct, based on Brady violations. The concealment of exculpatory evidence is a Brady violation, or intentional, kind of spoliation or destruction of it, or hiding it. You bring it at the appropriate time. Like, there are set procedures for when things take place and when you make these challenges. So despite the fact that these challenges are frivolous, even if they're brought at the appropriate time, this very idea of challenging the constitutionality of the very existence of special grand juries, it's the improper time. It's going nowhere. But it's showing that, look, Donald Trump is terrified, and his playbook is just paper the crap out of things, cause confusion, and then maybe we delay.
But let me remind everybody, the thing that they're attacking to move to dismiss is not even a thing that leads to an indictment. It is a process by which it guided the prosecutor, who ultimately has to still exercise her own prosecutorial discretion. And that's what's taking everyone's like, why didn't she just run right into the regular grand jury in March, there's one in March and there's one in May. We'll talk about that next, and just get the effing indictment. It's because it's one thing to make a presentation before a special purpose grand jury. And we've heard about some of the process that went on there. A little bit informal at times. It's another thing, as Karen has described, to go into a regular grand jury, which is an indicting body in which you can, you have to bring in your evidence. Sometimes you have to bring in the precipient witnesses with knowledge, bring them before the grand jury. Maybe you could read some transcripts that come out of the special grand jury process. Maybe you can't. But she's, that was just the beginning. That was just the starter's pistol for Fani Willis, for her team to say, okay, now how do we patch all these facts together that we developed in 7 months, put it with a charging document, ultimately with actual counts and claims under Georgia law and maybe a RICO civil conspiracy thing, and pull that all off. What I love about Fani Willis, she's not deterred by anything. She's not deterred by the white members of the legislature going after her in a racist way and all the other black prosecutors around Georgia. She's not concerned about that. This motion to dismiss is really just a press conference masquerading as a motion for Finling to be able to get on Ari Melber and start pushing whatever BS they have. And then she's just, Christina Bobb, come on down. Let's talk about what you heard when you participated in the infamous 11,780 vote phone call with Brad Raffensperger, because she was on the phone. And while you're at it, why don't you talk to us about the time you were in the West Wing with Mark Meadows in that office where he has that fireplace that burns documents illegally, and he was hosting Lindsey Graham, and Lindsey Graham said, you do a much better Lindsey Graham than me, but I'll try. Lindsey Graham said, "Can you just show me 5 dead Georgia voters? You can just show me 5 dead Georgia voters, or something I can go on television with. Anything. What do you got?" And they didn't have anything.
That's a good impression. I'm known for my Mike Pence impression of.
You're very good at Mike Pence.
I'm a Christian. I'm a conservative.
But your face also contorts into Mike Pence,
and I'm a Republican in that order. So if you want to kill me, just tell me you're a Republican and you could kill me.
So, all right. That's why people come here. They come for the analysis. They stay for the impersonations. But look, the good news and what we're trying to report and analyze is Fani Willis is full steam ahead. But imminent, unless people in Atlanta in the news media aren't following things the way New Yorkers follow things with grand juries, it doesn't look like she is presenting a thing to the March regular grand jury. The next regular grand jury in Georgia, in Fulton County, is May. Right. So May is going to be the time it looks like she's going to present her case. So if it's May, she's going to be behind Alvin Bragg, who's going to get it done in the next 10 days. She might even be behind. It doesn't really matter who's behind. This is just like competitive gaming that you and I are interested in. It doesn't matter. Justice will be done in the time that it takes at the moment it is right for that particular case. And nothing's going to move. If we've seen anything about these prosecutors, is that they are not influenced by each other. They are influenced by where the facts developed in their case leads them, and they will not prosecute a case before it's time or seek an indictment before they are ready, regardless of what you, me, our 14,000 people on the chat with us tonight think. It's just going to go at its own pace. And we're just here to follow it on a daily basis. So that's it for me on Fani Willis. Anything else before we move to the civil cases?
I don't think that Donald Trump should be prosecuted simply because I think he's a horrific person, which he is. He's a traitor, which he is. He was the horrific president. He should be prosecuted because he's a criminal, and he has spent his entire life engaging in criminal conduct to try to destroy our country, period. This is not a normal Republican. It's not a normal Republican issue about taxation or small government. Quite the contrary. The MAGA Republicans want to use government to attack prosecutors, right? We saw that with the House Judiciary Committee run by Jim Jordan, which is just even horrific for me to say that, sending letters to try to interfere with the Manhattan District Attorney's processes, trying to interfere with New York Attorney General Letitia James, which we're about to talk about as well, trying to interfere with all these prosecutions. Yes, so the people who are for states' rights want to use the House of Representatives to try to tamper with criminal investigations by local and state prosecutors. It's all a bunch of BS nonsense by a political party that has become a cult. And what we're seeing now is basically what the last days, or what should be the last days potentially of this, looks like if we all can just have the fortitude to say enough is enough. I know the Republicans are too weak right now, the MAGA Republicans, that is, to stand up to Donald Trump, to call out this behavior. But folks, This is the emperor with no clothes. This is as bad as it gets. He writes posts. He puts things in capital letters. At the end of the day, he's a coward. He's a coward. And not only he's a coward, he's a criminal, and you got to confront it.
He's also losing it. I mean, if the reporting is correct, he's walking around Mar-a-Lago like some scene, lost, forgotten scene from Citizen Kane, relishing the day when he's given his own perp walk and wearing handcuffs. This is from the New York Times. Plus, he's done things that talk about unhinged that even he doesn't usually do, like he's attacking Beryl Howell, the then chief judge of the DC Court of Appeal, Circuit Court, while she still sits over many cases that mattered to him, like the Rudy Giuliani defamation case related to the election workers in Fulton County. So he is, how do I put this in a legal term? He's losing it. Which is all par for the course, because we've seen this is the dark side of Donald Trump and his narcissism being played out writ large. And speaking of the emperor with no clothes, let's talk about the civil rape case, because the media in its first reporting, the mainstream media, got it wrong. All of the headlines, and that's why I jumped in and did a quick hot take, all of the headlines were judge rejects motion to consolidate trials, civil rape and defamation case indefinitely postponed. That is bad reporting. There's no other way to put it. You have to be able to read, if you're going to do legal analysis, you have to be able to read orders from a judge and understand what they're talking about. And let me explain, and then I'll turn it over to Ben. E. Jean Carroll originally filed a case about defamation because the Adult Survivors Act statute had not yet been passed in New York, allowing her to bring a civil sexual battery and assault case, because the statute of limitations, except for the passage of the new law, had already run on such a claim, and it certainly run on any kind of criminal claim related to that allegation. So what she had at the moment that she filed in 2020 was a defamation case, but at that moment was tied to a defamatory statement of Donald Trump denying that he knew her, denying that he raped her, denying that he was in the Bergdorf Goodman department store at that moment, calling it a hoax, saying that she wasn't his type, and all those other disgusting things. But he did it while he was president. And so there was a battle that broke out, an academic jurisprudential battle about whether a president was within the course and scope of his employment as president, because he's government employee number one, when he made these defamatory statements at a press conference. To us, it's simple. That's where you draw the line. Even Joe Tacopina, when he wasn't Donald Trump's lawyers, thought you're not allowed to be the defamer in chief, quote from Joe Tacopina. You can look it up, when you are going after this poor woman who claims that she was raped by you. Now, so there was a whole battle. It went up to the Second Circuit Court of Appeals Federal in New York. It even bounced out to not a state court, but a territory court. The District of Columbia's highest court for that territory. That district is an appellate court, because they needed to have a question answered about whether something was inside or outside the scope of the president's duties, to which that panel said, why are you, literally, I'm paraphrasing, why are you bringing us into this Second Circuit? We really don't want to answer. They did. We really don't want to answer this question, and they kicked the can down the road. Okay, this would all be interesting if that was the only case. But just this past year, at the November deadline, in fact, they were the first case to file under the Adult Survivors Act, Robbie Kaplan, the lawyer for E. Jean Carroll, filed a new civil rape case on the very moment that they could file it. There was a 1-year window that was opened for all adult survivors of sexual assault and battery and abuse to come and file their cases. And she filed the first one in New York in front of the same judge, and they always ran parallel to each other. She also added a second defamation claim related to not when Donald Trump was president, because that moron said the same types of defamatory things on social media when he wasn't president. And Ben, you were the first one to say, because we were doing Legal AF at the time, that guy just bought himself another defamation claim, because now it has no protection whatsoever. So she filed that second suit. That first suit, for those that are watching on YouTube tonight, I'm putting my hands next to each other, for those two suits ran parallel to each other in front of the same judge, and discovery, which is the obtaining of information between the parties in civil cases, they were running parallel to each other the whole time. The issue of whether the first case was going to be barred by a immunity doctrine that gives immunity to government workers for things they do within the course and scope of their duties, which we call the Westfall immunity. That became really not interesting at all after the new case got filed. And once the judge ruled that the new case wasn't going to be dismissed, it was going to be tried around maybe the same time, but not consolidated. So while the judge is ruling about all these things like, is the Access Hollywood tape going to come in? Are these other women who claim to have been sexually assaulted going to be able to testify? The parties, because you and I try cases, we're like, hey, I got another question. How many cases am I trying in April? Is it the civil rape case plus defamation 1 and 2, or is it something else? And so they wanted to force the issue. It's hard to believe that Alina Habba agreed to anything with E. Jean Carroll's lawyer, but they filed a joint letter. And they said to the judge, we got an idea. Let's combine all the cases in front of one jury at the end of April, because Donald Trump, he's not a total moron. He doesn't want to have 2 civil rape cases going and 2 defamation cases going. He wants 1. Right? So we'll try them together, Judge, and we'll send a letter to the appellate courts and tell them to hurry up and let us know by the 17th of April. And that's what we want to do. And so what did the judge do, who wears the black robes and makes all the decisions, Ben?
I want to hear your hot take is too good. I give
All
you.
right.
I'm enjoying watching you too much.
The judge said, I wear the black robe and I got a much better idea. Why do you want me to buy an appellate problem? And why, this is my paraphrase, my artist rendering of the judge. And why do you want me to pressure courts that are basically, including my bosses at the Second Circuit, when I don't have to do that? The cleaner case here is the second case that you filed, the one for civil rape and the one for defamation after he was president. I don't have the appellate problems. I don't have the problems of waiting to see what the Second Circuit or the other court's going to do. I've already said the civil rape case is going forward. And frankly, why do you even need the first case that you filed? Because if you win on the second case with civil rape and assault and defamation after he was president, isn't that all that you need? You may never even have to try the first case. So I think you're totally wrong, lawyers, on judicial economy. I think you're totally wrong about 2 separate cases, because there's a concept in the law that we call res judicata, or collateral estoppel, which means if you try one case involving the same exact parties, issues and facts that are developed there can be used in other cases that involve those very same parties. And so he says, so that's it. We'll develop facts. They may even apply to the other case, if and when we even have a second case. And I got a better idea. We try one case, it's the civil rape case, and it's April 25th. Now, Ben, why did everybody get that wrong in the first reporting and scare the crap out of everybody?
Well, I think it is actually very confusing with 3 cases, because look, what's very confusing about it, though, is that you have Donald Trump fighting to dismiss the first defamation case based on defamatory statements that he made in 2019 during a press conference while he was in office under, this presidential immunity that he believed he had. He had the United States government substitute in his name. He had the full weight of the DOJ and Bill Barr's DOJ behind him. And to be clear, while I thought it wasn't within the course and scope, I thought that was obvious, he at least had a decent argument, not based on the merits, but based on the unprecedented nature of how despicable he is to use the auspices and offices that he has to engage in that conduct. But then after taking on that fight for like 3 years, he then goes on his social media platform and posts word for word after he's out of office the exact same statement. And so what I said to you and what we did on Legal AF, I said they're going to file based on that post, because it's the exact same statement and they don't have to deal with the immunity issue. So you've got all of that. Add to it the fact that New York has this Adult Survivors Act so that it revives the statute of limitations for a 1-year look back period for sexual assault victims. And I get why it would be confusing. I've been very, 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 I've applauded Roberta Kaplan, E. Jean Carroll's lawyer. I think here she almost made a mistake, to be honest, that Lewis Kaplan fixed. And I think that she misread that Judge Kaplan just wanted to see things streamlined and coordinated and consolidated. And I think she didn't think Alina Habba would ever agree to it. And Alina Habba would want to delay, which they were trying to do. But what I do think Trump and Alina Habba are good at, and what they realized is if they could get Trump 1, the first 2019 case, in the mix with the 2 cases that are unassailable on appeal, they could put a poison pill in there and basically try to take down any ruling on the merits based on the underlying sexual assault and the defamation out of office based on their appeals to the kind of first case. That's why Alina Habba was willing to agree to it, because Trump 1 or E. Jean Carroll, the first case, Carroll 1 from the 2019 could actually be a poison pill when combined with the other ones. And it was the right ruling by federal Judge Kaplan here that basically says, look, if he defamed you here in 2022, and he said the exact same things in a case that has these constitutional issues that are being created because of how despicable Trump is, why are we going to grapple with these constitutional? We don't have to. Focus on the underlying rape, which is essentially the first element in the defamation case, because you have to prove that Donald Trump committed the act to then show that he defamed you by saying that it never happened in the first place. So you have to prove that the rape happened in the first element. And then if you prove the defamation, you've proved all of the cases, and your damages are basically they're going to be the same anyway. So it was actually the right ruling. But here's the thing too. And when we talk about the other case in New York, what all these judges are saying is, and literally this is Justice Arthur Engoron said this, which is, come hell or high water, we are going to trial.
Let me frame it. 4 weeks from today, you and I are going to be talking about a jury that was selected in a federal courthouse in New York on a civil rape case against Donald Trump. That's going to be what we're going to be talking about that night, along with the indictments and all the backfill that we're going to do. I got one last question for you, then I want to move on to the other big bombshell, which is not only is there going to be a civil rape case on April 25th, but some of the same lawyers slid over to Judge Engoron to try to get a 6-month delay of their case, and I want to talk about that. But here, I got a merchandise idea for the Meidas Touch merchandise store. It used to be on the back of milk cartons when children went missing. Where is Joe Tacopina? Because Joe Tacopina has been busy running around. He thinks he's Karen Friedman Agnifilo, appearing on every show that he can. However, there's a difference. Karen's a practicing lawyer. Tacopina makes these initial entrances, it stirs up the pot, and then he's nowhere to be found. He was supposed to be the lead trial lawyer because he said so in the E. Jean Carroll case. He hasn't filed anything in the last couple of months. He wasn't on the recent letter that was submitted, or he even carbon copied, CC'd on the letter to the judge. It's as if he miraculously, disappeared. And one other thing, just to make people feel more comfortable. The judge, for good measure, Judge Kaplan, not related to Robbie Kaplan, the lawyer, said, oh, and by the way, all those rulings that I made about Access Hollywood tape and the 2 women who were going to testify about being previously assaulted by Donald Trump, they're coming into the April 25th case. So there's no confusion about Carroll 1 and Carroll 2. That evidence slides over and slides in. He made that ruling a couple of days ago as well. Ben, why don't we talk about this other attempt by Alina Habba and Chris Kise. Remember Chris Kise took the $3 million and we barely see him anywhere, but he showed up again in Judge Engoron's chambers to try to argue, despite the fact that the judge in February said, his words, hell or high water, you're going to trial on October 2nd on this $250 million or more civil fraud case brought by the New York Attorney General. And I don't want to hear it. And he entered an order related to it. You better hurry up and get your discovery done. You've had 7 months. Let's go. Get your witnesses, get your documents, do your depositions. Hurry up. Let's go. And so that was February. So they run into court in March. And they say, oh, we need 6 more months. We got 30 more witnesses. And we haven't done any depositions. And we haven't looked at any documents. And, like they haven't done jack for the last 7 months. And therefore, they want to be given a do-over and given another 6 months, despite what the judge has said. And what happened, Ben?
Well, that got rejected. And the judge says it is etched in stone. That's a direct quote from Justice Engoron. And he had a number of other zingers there. That trial will happen October 2nd, 2023. I am not moving this case at all. And by the way, New York Attorney General Letitia James is seeking at least $250 million in damages. I'm sure she'll probably ask the jury for the billions of dollars of damages against Donald Trump, and an injunctive order, which would basically shut down Donald Trump and his adult children and some of the other defendants there, really from ever effectively doing business in the state of New York again, which will ultimately have the effect of potentially just shutting down the Trump organization and Donald Trump and his children from doing business there. One other point I wanted to make before. So New York Attorney General Letitia James knew that Donald Trump was going to make this move and try to delay. She warned the judge perfectly. As soon as this thing was filed back in September of 2022, she said to Justice Engoron, here is what Trump will do. He's going to try to delay it. Do not countenance that. We just want to preview for you what's going to happen, which forced Donald Trump's lawyers to basically say, no, we don't think we're going to need to do that. And then they were basically caught lying. I just want to read these zingers right here from Justice Engoron. These are things that he said during the hearing that took place this week. By the way, after Trump was railing against New York Attorney General Letitia James, there was a bomb scare which temporarily delayed this hearing and the ultimate order denying the delay request by Donald Trump. You see the real world consequences of his threats. But this is what Engoron said, the judge, quote, this case is complex, but it's not complicated. It all boils down to whether the statements of financial condition are true, and the rest, as Rabbi Hillel famously said, is all commentary. By the way, I love Engoron's zingers, and I love his quote of Rabbi Hillel to Donald.
Who brings up Rabbi Hillel and Talmudic commentary while he's handling
Well, to
this kind of
Donald
case?
Trump, that's an extra way to get under the skin of Donald Trump. And just a few more Engoron quotes, then I'll toss it back to you. Engoron also said, quote, I don't want to move this trial, not only because I said I don't want to move it, but that it is not necessary. And then Engoron also said, in terms of like why this case isn't complex, he said that, look, your defenses, Trump and Trump organization and your adult children are limited under New York law. And he said that the defense of, quote, everybody else was doing it and those parties could reach their own conclusions are not legal defenses, nor is saying no one was harmed by me is a defense to these claims. So it just shows you where Justice Engoron is here. He's had enough. And Donald Trump invoked the Fifth Amendment over 400 times in the special proceeding, which is an adverse inference in the case, meaning that you could have a situation where New York Attorney General Letitia James tells the jury, you could infer adversely against Donald Trump that the reason he didn't answer these questions is because if he did, he would be admitting to the allegations against him. And so this is a devastating case, and Trump's going to lose this case.
And I agree. And the other person that tipped off Engoron was Robbie Kaplan from E. Jean Carroll, who stepped out of her show into another. It was like she was like one of these cross-border shows where people appear on other shows. She wrote letters to 3 different judges telling them, get ready, Donald Trump is going to try to push your case into 2024. And then in 2024 is going to say, how convenient, I'm now a candidate for office for the president and I need to have everything delayed. Don't do it. Hold your ground. Stay where you are with your relative cases, and wherever you would think you should try it. Don't let him push it into 2024. She wrote a letter to Engoron, even though she's not before him in this case. She wrote another letter to another judge. You know, we don't talk much about it, but there is another civil fraud case, class action brought against Donald Trump and his children. This is why he's in so much financial jeopardy, almost as much as legal jeopardy, because between the 250 million, and it could be more than that, $250 million plus interest, which in New York runs at 9% a year. Okay, it's the best investment around right now. So you got that prejudgment interest, attorney's fees, that case, a civil fraud case involving a multi-level marketing company that he and his children promoted when he was on Celebrity Apprentice. That's also going for hundreds of millions of dollars. You add all these things up, and him being out of business in the state of New York if the corporate death penalty is given to him, all the things that criminal cases can't do. I mean, everybody was upset when Alvin Bragg, on the one hand, got 17 convictions of a Trump entity for tax evasion, but the fine was like $1.50. They were like, what? The fine? That because fines are not criminal justice. Fines are civil generally. And so then you go look at Letitia James and all the great work that she's doing. But this is what we're following. So, Ben, it's hard to believe that we have reached the end of another midweek edition of Legal AF. It's hard to believe it because between you, me, and Karen doing hot takes, it used to be on a day. I used to say on my hot takes, I do these about every day. Now I'm saying I do them about 7 or 8 times a day or an hour, depending upon what's happening. And that's another commitment that we made as anchors of Legal AF. And you were the pioneer on it. Not just to wait around for Wednesday and Saturday, which we thought was more than enough, but given the velocity at which things are operating, for us to be able to do it in real time and to analyze and distinguish things that mainstream media, whether they're former lawyers or not, are just not equipped to do. We are, so we do it. So if you like what we're doing here, and 14,000 people in live chat with us tonight says that you like what we're doing here, there's a lot of ways to support us, and they're all free. Okay. One of them is, if you like watching us on YouTube, go pull and free subscribe to the Legal AF podcast everywhere that you can subscribe to podcasts, and follow us there and leave a 5-star review. And then, and vice versa, cross-pollinate. If you like to listen to the podcast, go check out and click the subscribe button for MeidasTouch. We are so close to 1 million subscribers on the MeidasTouch network. Oh, we are close. So go there, help contribute to that. I feel like we're on a Jerry Lewis telethon right now. Go add another 1,000 or 5,000, whatever we need. Then, so do that back and forth. That's free. It's all free. Everything's free. We've got a merchandise store that has some great merchandise. Maybe Salty, our producer, I'll put up a clip of the Legal AF stuff, MeidasTouch stuff that you can get. And then I'll surprise Ben on this one. There is Patreon. If you want to be a Patreon, if you want to be a patron, you can subscribe to things related to MeidasTouch. It keeps this whole big thing kind of going. And Ben has threatened me that he may bring me on so that I can address some of the Patriots in a special Legal AF breakout show. And we'll do that as well. But that's it, man. That's how we are supported. We are completely grassroots. 99% of what I just outlined for you is free, totally free, but keeps us on the air, in the rankings, knocking on the doors of the big guys in all the rankings. I mean, I pinch myself every day. I look at what just Apple Pod ranks us in terms of news and news analysis, top 10, top 30. I mean, just ridiculous numbers that you and I invented this show in a garage 2.5 years ago. And here we are now. Ben, final word.
I pinch myself every day that I get to do this with you, that I get to do this with Karen Friedman Agnifilo, that I get to do this with my younger brothers, that I get to do this with all of our incredible contributors. And last but not least, that I get to do this with all the Meidas Mighty out there. None of this, and I mean none of this, is possible without you. This is truly a grassroots media network. This isn't some top-down, hierarchical, sterile network. This is a movement that you all have created. And it's an honor every morning to wake up talking about justice, but frankly, doing justice for you. You deserve the facts. You deserve the truth. And unfortunately, large media networks have just not risen to the moment. But that's why each and every day we'll continue to work so hard to make sure that we're not just giving you opinions. We're not just yelling. We're certainly not both sidesing the issues. This is about going through the court filings. This is about having the top experts in the country on these issues, and in some cases, the top experts in the world, breaking down these issues for you so we can cut through BS narratives and give you the facts in ways that you appreciate and, most importantly, that you deserve. Popok, I'll give you the final word.
You're so polite. When I was a kid, and I'm going to date myself here, McDonald's literally on their sign would change the numbers for how many hamburgers they sold. Who remembers that out there? They eventually started writing billions and billions and billions, and now they don't even do it at all. But when I was a kid, like in the 70s, I would like when it would go from 1,738,000 hamburgers. We are, according to the chat tonight, we are less than 20,000 away, which based on MeidasTouch time is like 2 weeks away from 1 million free subscribers on the MeidasTouch network on YouTube. It's hard to believe. Ben, what do you think? 2 weeks at the rate we're going?
Well, we're marching to 1 million subscribers. So for me to do the march, we're trying to do it in March. So
all right.
we want to
March
set those
Got
ambitious goals. So please subscribe right now if you haven't subscribed. And do us this favor. Send the YouTube channel to friends, family members, coworkers, colleagues. Tell them to subscribe if they haven't already subscribed and help us get that goal. That would be great. Popok, any final word? Or
no, except for one thing. See you Saturday, and Lord knows what will accumulate between Wednesday and Saturday, and see you every hour on the MeidasTouch Legal AF network. Wait, there's something else? There's something else?
And the audience knows it. And
what am I doing? Shout out to the Meidas Mighty? What am I doing?
Yeah.
Shout out to the Meidas Mighty.
Shout out to the Meidas Mighty.